The Suspicion Clause by common interpretation by Amy Brett and Nyoki Kanyo. The Suspicion Clause protects liberty by protecting the privilege of the writ of habeas corpus. It provides that the federal government may not suspend this privilege except in extraordinary circumstances, when the rebellion or invasion occurs and the public safety requires it. Appreciating the significance of this restraint first requires understanding the writ of habeas corpus. This writ, which Americans imported into the Constitution from English common law, is a means by which a prisoner can test the legality of her detention. A person who believes she is being imprisoned illegally can file a petition asking a judge to issue a writ of a habeas corpus. When a prisoner files a petition for the writ of habeas corpus, her custodian must explain why the restraint is lawful. If the explanation does not satisfy the court, we will order the custodian to release her. The writ is thus a crucial means by which a prisoner can obtain freedom. This writ of habeas corpus is primarily used by those serving prison sentences to challenge the illegality of the process that resulted in their conviction. Historically, however, the writ was primarily used by those imprisoned without judicial process. Early Americans were keenly aware that the monarchs of England had sometimes jailed people indefinitely without charging or trying them in court. Although the writ of habeas corpus existed, the king often ignored it. To protect against such abuse, Parliament enacted the Habeas Corpus Act of 1679 to ensure that the king released prisoners when the law did not justify confining them. This great writ guaranteed prisoners held on authority of the crown the right to invoke the protection of the judicial process. The founding generation valued the great writ because it had its history in mind. Yet those who framed and ratified the Constitution also believed that in times of crisis, executive might need levy to hold suspects without answering to a court. Parliament had suspended the writ during the 17th and 18th centuries when it concluded that the king needed expanded detention power to contain threats. Similarly, several states had equipped their governors with emergency power by suspending the writ during the Revolutionary War. Pre-ratification practices embrace both the importance of the writ and the need for the safety valve. The Suspicion Clause follows in this tradition. It protects the writ by imposing a general bar on its suspicion. At the same time, makes an exception for cases when an invasion or rebellion endangers the public safety. A suspicion is temporary, but the power it confers is extraordinary. When the suspicion is in effect, the president, typically acting through subordinates, can imprison people indefinitely without any judicial check. The clause does not specify which branch of government has the authority to suspend the privileges of the writ, but most agree that only Congress can do it. President Abraham Lincoln provoked a controversy by suspending the privilege of his own accord during the Civil War, but Congress largely extinguished challenges to his authority by enacting a statute permitting suspension. On every other occasion, the executive had proceeded only after first securing congressional authorization. The writ for habeas corpus had been suspended for a time since the Constitution was ratified throughout the entire country during the Civil War. In 11 South Carolina counties overrun by the Ku Klux Klan during Reconstruction, in 2 provinces of the Philippines during the 1905 insurrection, and in Hawaii after the bombing of Pearl Harbor. The most hotly debated question concerning the suspension clause involves its effect in the absence of a former suspension. Threshold questions whether the clause simply restrains Congress' ability to suspend whatever habeas jurisdiction is currently on the books, or whether the clause grants a affirmative right to a habeas review or an adequate substitute for it. On the one hand, the clause general bar on suspension assumes that some access to habeas relief will exist when the privilege rate has not been suspended. On the other hand, and Chief Justice Marshall noted in Ex parte Bowman 1807, the clause does not itself expressly guarantee that access. The court seemed to have resolved this dispute in Bimini versus Bush, 2008, where they held that the clause does not simply restrain Congress's ability to suspend existing habeas statutes, but affirmatively guarantees prisoners some forum in which they can challenge the legality of their detention. Also, in Bill Minden, the court decided, to much controversy, that a habeas jurisdiction extends to prisoners detained outside the United States and Guantanamo Bay. U.S. years rate is most commonly sought by convicted defendants in state prison. Each year, over 18,000 petitions for the rate of habeas corpus are filed in federal court by state prisoners against their prison wardens, but a very slim fraction of those petitions are actually successful, in part due to the limits Congress placed on federal courts reviewing habeas petitions when it enacted the Anti-Terrorism and Effective Death Penalty Act for 1996. EDPA significantly limited federal courts' power to grant habeas relief for state prisoners. The question about the scope and limits on the grade rate are far from settled. Both the Supreme Court's Guantanamo decision and EDPA remain controversial as we grapple with founders' vision of the rate and the proper balance to strike between liberty and security. Matters debate. The Scope of the Suspension Clause by Amy Brandt. American citizens held by the United States have the right to seek the rate for habeas corpus, whether they held at home or abroad. Non-citizens held within the United States also have the right to seek the rate. Boumediene versus Bush, 2008, extends the right to assert category detainees, non-citizens held outside the territory jurisdiction of the United States. The case is controversial because its holding, which has significant implications for national security, is contrary to precedent and unsupported by the Constitution text and history. Boumediene was not the first case in which the Supreme Court confronted the argument that a non-citizen enemy held abroad is entitled to seek a rate of habeas corpus in an American court. In Johnson versus Anson Trader, 1950, a case decided in the wake of World War II, 21 German citizens held in an American military facility in Germany petitioned for the rate, maintaining that their detentions violated both the United States Constitution and international law. The Supreme Court held that as American courts lacked authority to entertain these petitions. It observed that the constitutional text did not expressly confer such a right, and that no court in history has ever instituted a rate of habeas corpus on behalf of a non-citizen held captive outside the territorial jurisdiction of the United States. Boumediene abandoned Anson Trader's bright light test based on sovereignty and citizenship in favor for multi-factor tests that extend habeas jurisdiction to locations where courts think it is reasonable to do so. In Boumediene, the court asserted that the U.S. Constitution grant non-citizens imprisoned in Guantanamo Bay, which is in the sovereign territory of Cuba, the right to seek habeas corpus in federal court. Its conclusion rests on three. Consideration 1, the fact that the detainees disputed their standard as enemy combatants. 2, the court's determination that the United States has functional control over Guantanamo Bay. And 3, its judgment that forcing the military to participate in habeas proceedings would not compromise national security. It then held that the Military Commissions Act, which permitted petitioners to challenge the legality of their detention in military tribunals but not federal habeas proceedings, was unconstitutional. Reasonable people disagree about the wisdom for empowering the judiciary to second-guess the military's decision, often made on the battlefield, to classify a prisoner as an enemy combatant. Boumediene, however, was not about choosing sides in that policy debate. It was about determining what the suspicion clause required. The court struggled to justify this new rule as one imposed by the Constitution because the text of the suspicion clause does not specify the scope of the protected habeas right. The court has always defined it as with reference to history, and the Boumediene court considered that the historical record failed to establish that the court had ever entertained habeas petitions filed by non-citizens held in other countries. The dissenters who maintained that the suspicion clause did not override Congress' choice to define federal jurisdiction, and the better of the argument. Whether Boumediene is right or wrong, it dealt with the core office of the writ, testing the legality of executive detention. The application of the suspicion clause in the post-conviction context is much less certain, because habeas was not a tool for obtaining post-conviction relief at the time the Constitution was ratified. The founding generation could not have understood the clause to protect this use of the writ. Congress made post-conviction relief for state prisoners available in the late 19th century, even if legislative expansions of the writ ratchets up the protection offered by the clause, a proposition that the court has never squarely embraced. Congress surely has more flexibility to shape jurisdiction here than it does in the executive detention context. Next perspective, the suspicion clause by Neil K. Candia. A view on Congress' power to limit the rate of a habeas corpus. Over the past 2 decades, Congress has made several efforts to limit the availability of the rate of a habeas corpus. In 1996, it passed Anti-Terrorism and Effective Death Penalty Act, ADPA, which prevented the president from filing multiple habeas petitions and mandated a differential standard of review of state court decisions. In 2006, Congress stripped from the federal courts the power to grant habeas relief to enemy combatants imprisoned outside the United States. These laws present difficult and controversial constitutional questions. Does the writ extend outside the territory of the United States? How much deference should the court give Congress and the executive in determining the scope of habeas relief, equally in national security cases? I argue that Congress has the authority to regulate the availability of habeas corpus relief through laws like ADPA, so long as the afford person with plausible innocence claims an opportunity for relief, but then Congress does not have the authority to withhold habeas relief from combatants detained and prisons like Guantanamo Bay that are under complete U.S. government control. Anti-Terrorism and Effective Death Penalty Act, ADPA. ADPA has 2 principal effects on the availability of habeas relief. First, impose procedural limits on habeas petitions, including a 1-year statute of limitations and bar on successive plantations. See 28 U.S.C. Clause 2244. Second, it requires federal courts to employ a differential standard for review when reviewing state court decisions. See 28 U.S.C. Clause 2254. I believe that the EDPA, at least as drafted by Congress, appropriately sets the contours for habeas relief. My perspective is informed by the influential views of the great Judge Henry Friendly. To Judge Friendly, the Court of Habeas Corpus Relief concerns prisoners with colorable claims of innocence. Accordingly, Judge Friendly believes that the Congress could enact procedural and substantive limits on the availability for habeas relief. EDPA codifies such limits. Moreover, EDPA largely preserves what Judge Friendly believes to be the essential function of habeas, ensuring that the innocent have opportunity to validate their claims in a federal court. See Henry G. Friendly, is innocence irrelevant collateral attack on criminal judgment. In interpreting EDPA, the Supreme Court has at times vindicated the innocence view, and at times threatened it. In McQuiggan versus Perkins, 2013, the court correctly allowed exception to EDPA's 1-year statute of limitations for a person with a strong claim of innocence. In other cases, such as Woods versus Ethron, 2016, however, the Supreme Court has elevated the standard for habeas relief so as to make it nearly impossible for prisoners, even innocent ones, to obtain relief. So while I believe EDPA as a general matter is consistent with the Constitution, I harbor concerns about the differential standard for review of state court decisions mandated by the Supreme Court. Congressional limits on the exterritorial scope of habeas corpus. In response to Supreme Court decisions holding that the grade rate was available to certain enemy combatants detained during the War on Terror, Congress passed the Military Commission Act, MCE, in 2006. The MCE stripped U.S. courts of the power to consider habeas petitions for enemy combatants held outside the United States. 2 years later, the court held that the MCE unconstitutional as applied to combatants detained in Guantanamo Bay in Boumediene versus Bush, 2008. In reaching this conclusion, the court balances 3 main factors: 1, the citizenship and standards of the detainee; 2, the nature of the sites of apprehension and detention; and the practical obstacle. Wow, that's interesting. Okay. Hold on. Wow, that's so crazy. Anyway. Let's see. Suddenly gone somewhere else, so. Okay, I'm gonna come back to this. I hope here we go. Wait a minute. Okay, so it's Article 1 going to be suspicion clause. They're gonna matter debate the second opinion. Good. Okay, I'm so sorry. Anyway, okay, here we go. Let me pick up from where we left. In reaching this conclusion, court balanced the 3 main factors: 1, the citizenship standards of detainee; 2, the nature of the sites, apprehension and detention; 3, the practical obstacles in resolving a prisoner entitlement to the rate. With regard to Guantanamo, those factors leaned in favor of the availability for habeas relief. In particular, the court noted that the U.S. government exercised complete total control over the prison. In 2010, the Sixth Circuit Court of Appeals reached the opposite conclusion with respect to enemy combatants held at the Bagram Air Base in Afghanistan in AL Manklang versus Gates. Applying the court's three-part test, it concluded that the combatants were not considered entitled to file habeas petition in U.S. courts. Reaching this conclusion, court noted that the combatants were detained, quite literally, in a war zone, and this reality posed immense practical obstacles to allowing habeas proceedings in U.S. courts. In my view, this decision strikes the right balance between preserving the right, the check on government authority, and safeguard the personal liberty while giving the executive branch space to operate in times of war. Well, the next perspective is that it's the scope of the suspension clause by M.E. Brett. American citizens held by the United States have the right to seek the writ of habeas corpus whether they are held at home or abroad. Non-citizens held within the United States also have the right to seek the writ. Boumediene versus Bush 2008 extends the right to assert category detainees. I think I read this, so I had to do this later, I guess. Well, I got wrong. But anyway, I'm going to read this short article. So, non-citizens held within the United States also have a right to seek the writ. Boumediene versus Bush 2008 extends the right to assert category detainee. Non-citizens held outside the territorial jurisdiction of the United States. The case is controversial because its holding, which was significant, has significant implications for national security. That's right. I already read this. That's why. That's the first opinion. So we're going to stop here. And I don't think I'm going to read it again. So that's that.